Thank you so much, Linda. Thank you so much, David and Chris and John. And I'm really excited to be here at the 4th Artist Rights Symposium. Thank you also to our AU students who got us across the street. We almost lost a couple of us. Copyright experts are good at copyright, but not always everything. We have about 15 minutes. This is going to be a bit of a speed date, so let's dive right in. I'm going to be calling on the audience and embarrassing people as we go. So Amy, get ready. No, that's not true. Okay, so first of all, what we're going to be talking about today is a quick survey of what's going on in the international policy space. We're going to be looking at some national jurisdictions, but we're also going to be looking at some regional and international efforts to address AI governance issues. Sometimes that is about copyright, sometimes that's not about copyright, but manages to bring copyright into the equation. Mostly these government conversations are talking about two basic issues. How do we deal with inputs, in other words, the training of AI models, and how do we deal with the outputs? That could be generative AI, for example. So let's jump in. Jumping? You're jumping. There we go. All right, so first of all, we're going to focus most of this time on the input side. When we talk about inputs, we're talking about when content is used to train an AI model and whether or not there are copyright equities involved. And there are, just to jump to that, just to get to that moment. So what are those copyright equities? I think a lot of us know what those probably are, but just to make sure we're all on the same page. First of all, is there consent? Is there compensation? Has there been an understanding, whether it's an arm's length transaction, a commercial agreement, a license? Has there been any type of consent, authorization, permission granted to use the content to train the AI model? That is a fundamental aspect of copyright. And the question is, how do we know if a piece of content, if some copyright protected content is been incorporated into or been used to train an AI model? Well, that requires transparency. That requires record keeping. That requires other aspects of transparency. And governments are looking at whether and how to require or otherwise include in their regulatory systems that aspect. Because if you go to court and say, we think as a right holder, as the copyright holder, we think our song, our sound recording, our musical work is included and been used to train an AI model, and the judge will ask, how do you know that? And you can't demonstrate that. It is very difficult to enforce your copyright in that jurisdiction, and probably any jurisdiction. So this is what governments are looking at these days. So we're on the input side. On the output side, the question is a thing, we're not going to call it a work, we're not even going to call it a creative piece of content, we're just going to call it a thing that is generated by an AI model. Is that copyright protectable? And does it infringe an otherwise existing copyright? And I'm watching you, Susan, to make sure that I'm on the right path. So just give me a little, good, thumbs up. So who's addressed these issues so far, and to what extent? The Japanese government, the EU government, Singapore, and the UK. The UK was first in 2014 with a very narrow copyright exception for text and data mining, effectively limited to academic work, research, non-commercial use, no real transparency provisions, but also no opt-out and no other sort of aspects to muddy the waters. It's a fairly narrow, it's a fairly limited copyright exception for text and data mining. This was before ChatGPT. This was really before generative AI launched onto the scene, and all the complexity of that issue with respect to copyright really emerged. So UK started it. Then we saw Japan. In about 2019, they moved very broadly from a narrow copyright exception for text and data mining to a extremely broad, what we might call the nadir, the low point of copyright exceptions for text and data mining, soon to be outdone, but at least at that point in 2019, it was Japan. Japan really didn't know exactly how it would be implemented and really relied, and government sources have confirmed, they relied on litigation to help clarify what the meat and scope of that was going to be. Japan is not a litigious society. They're not so blessed as we are here. we haven't really gotten a lot of clarity around what the scope of that provision means, which is obviously leads to massive legal uncertainty and a lot of concerns. Then we talk about Singapore. Singapore basically took what Japan did and cut and pasted it into their law. Japan is very much working on its attempt to become not only a national AI hub, but a regional AI hub, and is driving this copyright agenda for text and data mining, not only within its national borders, but throughout the entire region. It's also working in places like Geneva at the World Intellectual Property Organization, the National Economic Forum, which meets annually of all the sort of major governments in a beautiful ski village in Switzerland, and is trying to push this copyright text and data mining agenda, which is part of, if you want to drive a good AI economy and attract foreign direct investment and offshore a lot of U.S. jobs, then that's a great place to go. So then you've got the EU. The EU is the latest in time model of what a text and data mining regime could look like in a national, or in the case of the EU, a regional law that applies to some 26, 28 member states. What the EU has done is they've done about 2 or 3 major things. First of all, they've included a copyright text and data mining provision in their law, but they've divided it into 2 basic categories. Commercial use and non-commercial use. For non-commercial use, there is no opt-out. It is a full exception. There are certain limitations around that use and who may use and how that may be used and deployed. With respect to commercial use, they have introduced what is called an opt-out provision. This opt-out provision gives a right holder, a copyright holder, the opportunity to opt out of this exception. This is absurd. I encourage you all to read a great new article by Ed Newton-Rex, which explains technically why this is very difficult to do. Why this is very difficult to do is for several reasons. First of all, the technology, the onus of developing how to opt out is on the right holder, rather than the technology provider, the AI developer, who's then going to read it. And you can imagine what their response will be like. Hey, nice try. We can't read it next, and we're going to download. We're going to use it to train. We didn't see it. We didn't know about it. Wrong. I've been very bad at ISRC and ISWCs, but wrong ISRC, right? Like, you can imagine all the ways that this can be avoided, circumvented, ignored, et cetera. So the speed bump will be certainly sped past is a major concern. Then the EU has done something on transparency. It's really the first major jurisdiction to address transparency. And they've done transparency in a sort of their language is a sufficiently detailed summary. So that's tantalizingly awkward, right? So it's some information, but perhaps not enough, but maybe. We've been told by commission officials that yes, that would be enough. This would be enough information to use in a courtroom proceeding to satisfy that evidentiary burden I talked about before. Unclear. The way that the legislation is drafted, we would have liked to see something much broader and something much more clear, more information to be provided, right? But this is in the process now. The European Union has established a separate AI entity, which is now currently, literally as we speak, working on developing what that standard is for that type of disclosure, that type of record keeping. And finally, they have developed a third piece of the law, which we look at as very important, which is that you must abide by EU law when you are training and when you are deploying an AI model in the EU. So in other words, if you go to Japan or Singapore or the UK and train a model there, inconsistent with EU copyright law, it is a violation of EU copyright law should that AI model then be used or there's a nexus with EU law. So that's actually a very important element to this that we love to remind Japan and Singapore about, which is like, you guys, if you would like to be an AI hub, just assume that your companies have to, they're excommunicated from the EU market, which is pretty big. So that's the current state of EU text or of global text and data mining law. But that is not where it will stop. We see deliberations happening globally. We see them happening in Brazil, in Colombia, in Chile, Hong Kong, and the UK has now decided to revisit the conservative government, of which there were 3, 4, 5, 6 prime ministers, I've lost track, Now we have a Labour government. We have a Labour government in the UK. They are now revisiting this question. The UK Intellectual Property Office 2 years ago made a proposal for a full-blown text and data mining exception with no limitations to type of content, commercial, non-commercial use, opt-out, non-opt-out, and a variety of other factors. Those were ignored. But that ultimately, the Conservative government decided no, after there was a massive reaction from the international creative community in the UK regarding that. However, we have a new Labour government. They are reconsidering a possible text and data mining exception with the possibility potentially of an opt-out provision. So that is something we're very much closely monitoring. The UK, like Japan, is a massive market for music. It's the third largest sound recording market in the world. Japan is the second largest sound recording in the world. But that's also not it. We should think about, obviously, national jurisdictions first, but there are AI governance dialogues taking place around the world. And in the last couple of minutes, I just want to do a quick tour through some of those. The Council of Europe, which, by the way, is not an EU, European Union institution. That's a separate body, which includes the US. It includes Canada. It includes several other countries outside of the EU. They actually have a binding international treaty on AI. It's extremely high level, as you can imagine, but it deals with things like human rights. And the last time I checked, copyright and creativity is in the UN Declaration on Human Rights. I believe it's Article 27, but we can all double check. And that's important because the fact that human rights has been recognized by the UN to include copyright means that there is some angle here to think about as we look at the global governance issues around copyright. We've also seen a lot of soft law, right? So not internationally binding commitments, but commitments at a political level between governments. And this has taken place on a regional level and also on a sort of a economic level. So for example, G7, the group of 7 countries, Japan, US, Canada, China, not China, wrong, Japan, Italy, Germany, and the UK, and France. That's probably 8, but anyway. G7, they have, since the Trump administration, I went back and checked, since 2017, the G7 has had statements on AI that talk in greater and lesser detail about the importance of protecting intellectual property rights, promoting intellectual property rights, promoting transparency, promoting responsibility. These are all words that we like and that we support. In fact, most recently, earlier this year, including the Labour government, the new Labour government in the UK, issued a statement of culture ministers, which went through a detailed listing of all the tremendous benefits that culture brings and how we must ensure that AI developers are respecting copyright, that AI developers are aware of the policy positions of the creative community, and that the creative community is brought into the AI governance conversations globally, which are taking place, as you can see, kind of constantly and around the world. ASEAN, the Association of Southeast Asian Nations, this is a group of Singapore-led countries. The US is an observer, Japan is an observer. They issued a statement back in February, very problematic, which basically said, hey, if you have fair use, you're good for text and data mining. We reacted strongly to that statement as both not only a false characterization of fair use, which nobody has in Southeast Asia except for Singapore, but also a problematic statement as a global standard. The U.S. government went in and kind of righted the ship, issued a ASEAN-U.S. leader statement. So President Biden and ASEAN leaders issued a statement that said, thou shalt respect copyright in the context of AI. We're tremendously grateful to the US government for its tremendous work in these fora to help promote and protect copyright in the context of AI. WIPO, the World Intellectual Property Organization. This is an organization that has global remit and is sort of the authority under the UN to address intellectual property rights issues. More and more, there's an agenda on exceptions and limitations there. WIPO is a treaty-making organization, and there are those who support AI and text and data mining who would look to seek to develop a treaty in WIPO on these issues, so on text and data mining, et cetera. So that's something of great concern. And finally, we have trade agreements. The US government got out of the trade agreement business for the last 4 years, but could very well re-enter the trade agreement business. For those who don't know what trade agreements really are, they are binding contracts between nations with very specific commitments around copyright issues, for example, among many, many others. The Obama administration had a trade agreement called the Trans-Pacific Partnership Agreement. That included the DREAD balance provision, which basically was a kind of a quasi-fair use provision. The Trump administration decided when it did the US-Canada agreement not to move forward with the DREAD balance provision and left it out. So that is very important to remember. And tech companies tried to add a text and data mining provision into that balance language, which we had no idea at the time how bad that really was. They knew something we didn't. But luckily, the Trump administration decided not to accept that proposal to add a text and data mining exception into the DREAD balance language, i.e. a fair use provision. The idea that we would have trade agreements in the United States with foreign countries promoting the use of fair use and linking text and data mining to it, that could have been catastrophic. Thankfully, that was rejected. There are, however, trade agreements between the UK and other governments which include fair use language. The UK doesn't have fair use, but that came from that agreement, that TPP agreement. So maybe I'll stop there. I think I'm kind of at time, but that was a quick kind of car wreck of a presentation, but I hope it was somewhat informative. So thank you.